Good. Two more additional interventions. Maître Paul Skolnick first, and second, Maître Ian Edwards.
Good afternoon. One of the things that bothers me that we haven't touched on today, but is ancillary to this whole question of lying and perjury, is the issue of witnesses testifying in secret, so-called witness protective measures. So this person that Alison Turner mentioned, GAA, the public at large doesn't know who GAA is. The lawyers know who GAA is in the case because we have unredacted statements showing who he is. And we're bound by the witness protection orders that we could never reveal this to anyone. And to show you how seriously a breach of that is looked upon, a journalist at The Hague breached a witness protection order where the journalist's defense was, well, everybody knew who this person was. That journalist was fined 35,000 euros. So we're talking about, you know, the system coming down very hard on the perpetrator who reveals classified information. So now, the reason I bring this up is the following. It seems to me, and I saw this in the ICTR cases in which I was involved in, which are 2 cases, and also when I did the Munyaneza case here in Canada, which was the first genocide case under the new legislation, all the prosecution witnesses testified with pseudonyms, and all the defense did as well, all the defense witnesses. Now that really bothered me because I knew that a lot of these witnesses testified at gachachas in Rwanda under their own names. So why did the prosecution have to have witness protection for them when they come to testify at the ICTR or when they came to testify here in Canada in the Munyaneza case? And the problem is compounded by the defense lawyers because we were all afraid that if we wanted to bring witnesses from Rwanda to testify and they would testify under their own names, they would be afraid and suffer reprisals from the Rwandan government. So I bring this up because it's something to think about. And in retrospect, when I really think this out, I have come to the conclusion that this witness protection business does not serve the interests of justice. What it does is it provides a screen and a camouflage for witnesses to recount all kinds of lies that they would never say if their real identities were known. So if a witness would say, for example, I was at the Nyangi church when the bulldozer knocked the church down on 2,500 Tutsis, and everybody in his cellule or in his county or in his parish knows that this guy was never in the Nyangi at that time that the church was demolished, that witness would never say such a horrendous lie. So I just bring this up so that you should all think about this, because there are going to be more cases in Canada, and the prosecution is going to ask that all the witness protection measures be issued for their witnesses, and the defense is going to do the same thing. And it may not be in your interest, if you want to have a fair trial, to have that kind of a system. Thank you.
Ian Edwards, thank you for your presentation, Beth. When you mentioned the case of Dominique Naukurieo, I couldn't resist, so perhaps you can allow me a bit of self-indulgence. That was the first case of which I was a member of the defense team. And to put a bit of flesh on the bones of that particular case, unless I'm mistaken, it's the first and only case in which that defendant was convicted by a majority of the judges. One of the judges in the Naukurieo case acquitted him completely of all offences. Of the 2 remaining judges who were, to a much greater extent, old hands at the ICTR, I won't name names, but they're public. No. All right, then, okay, why not? Judge Khan and Judge Mutoga. Old hands, as I say. They did pot him. They did convict him, but on the basis of only 2 of the original 14 witnesses. So 12 of the prosecution witnesses had been sufficiently, undermined in cross-examination such that the court didn't rely on them. 80% of the individual allegations relating to Naukuriayo in the indictment were done away with. What that effectively means arithmetically is that he was convicted in the first place of 25 years on the basis of 2 witnesses' evidence. And only 2 judges thus convicted him. So perhaps that putting a bit of meat on flesh on the bones of what Beth has just said, that may give some of you an idea of, in reality, what is meant by the terms casual and lackadaisical and cavalier attitude towards towards the fact-finding exercise. Thank you.
Thank you. Thank you.